Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, SOL, Postgraduate Diploma in Intellectual Property Rights, PGDIPR, MIP 104 Trademarks, Domain Names Geographical Indications, Block-1 Trademarks-I, Unit to Protection of Trademark Rights in India-1, 2.1 Introduction. Trademark rights could be acquired either by use or by registration. The Trademarks Act, 1999 provides elaborate procedure for registration of trademarks. Trademark registration brings forth various advantages. It is the right of the proprietor of a trademark to use his trademark and exclude all others from such use. However, trademarks cannot be registered only for the purpose of hoarding. Therefore, their non-use or improper use may lead to cancellation of registration. This unit attempts to lay down the procedure for registration and cancellation of trademarks. 2.2 Objectives. After studying this unit, you should be able to times elaborate how trademark rights are acquired, times in what manner use of a mark helps in acquisition of rights, times explain the need and process of trademark registration, times what are the absolute and relative grounds for refusal of registration of trademarks, times describe the rights arising from trademark registration, and times describe the grounds on which a trademark can be removed from the register. 2.3 Acquisition of trademark rights. Trademark rights could be acquired on the basis of either use or registration. The use system is based on the objective facts of trademark use and decides the ownership of a trademark according to the time that the trademark was first used. While the registration system grants trademark rights according to registration, and the first applicant will obtain the trademark right. Both systems have developed historically. However, the use system predates the registration system throughout the world. The trademark protection systems today generally combine both the elements of use and registration. Even in the presence of a fully developed registration system, use continues to play an important role. However, in countries that have traditionally based trademark protection on use, the registration of a trademark merely confirms the trademark right that has been acquired by use. Consequently, the first user has priority in a trademark dispute, not the one who first registered the trademark. In that sense, one acquired trademark rights with the first use of the mark. In India, registered trademarks are governed by the Trademarks Act, 1999 and common law, whereas unregistered trademarks are governed by the law of passing, of which is a part of common law. 2.4 Registration of trademarks. The Paris Convention places contracting parties under an obligation to provide for a trademark register. UR 150 states, including India, are members of the Paris Convention. So, nearly all countries today provide for a trademark register. However, registration of trademarks is not compulsory in India. That means even without registration, and just on the basis of use, a trader can acquire trademark rights. Nevertheless, trademark registration brings forth certain advantages which are not available to a trade over a trademark obtained under common law. 2.4.1 Advantages of registration. Trademark registration brings forth following advantages. Registration usually gives a party the right to use the mark nationwide, whereas unregistered trademarks acquire rights only in the territory in which it is used. Times registration constitutes nationwide constructive notice to others that the trademark is owned by the party. Times registration enables a party to bring an infringement suit, whereas the owner of an unregistered trademark has the remedy of passing off alone. In all legal proceedings relating to a registered trademark, the registration of the trademark shall be prima facie evidence of the validity thereof. Section 31(1) TMA 1999. Fourth, registered trademarks can, after 5 years, become incontestable, at which point the exclusive right to use the mark is conclusively established. Times where the proprietor of an earlier trademark has acquiesced for a continuous period of 5 years in the use of a registered trademark, being aware of that use, he shall no longer be entitled on the basis of that earlier trademark to apply for a declaration that the registration of the later trademark is invalid, or to oppose the use of the later trademark in relation to the goods or services in relation to which it has been so used, unless the registration of the later trademark was not applied in good faith. Section 33(1) TMA 1999. 2.4. Use requirement. Upon registration of a trademark, trademark registration not only gives a right to the proprietor to the exclusive use of registered mark, but it also makes such use obligatory. If the registered mark is not used, then the proprietor may lose rights over it. However, trademark owners need a grace period after registration before the use obligation comes into effect. This becomes particularly relevant in the case of businesses that are active in international trade. In order to avoid loopholes in the protection of their new trademarks of which competitors could take advantage, they must from the very beginning apply for the registration of their new trademarks in all countries of potential future use. Even in their own countries, businesses often need several years before they can properly launch a newly developed product on the market. The grace period granted in trademark laws that provide for a use obligation varies between 3 to 5 years. 2.4.3 Notice of use of a registered trademark. Technically, no notice is required as to the use of a trademark. Making notice of a trademark being used on goods compulsory is prohibited by Article 5D of the Paris Convention, and consequently only a few laws provide for such notices. However, it is advisable to highlight the trademark, that is, to make it stand out from its surroundings, and it should be identified as such by a trademark notice. It is usual to use the symbol registered trademark symbol, i.e. the circled R. Over the years, this symbol has spread throughout the world and become a widely recognized symbol for a registered trademark. Its use recommended for registered trademarks as a warning to competitors not to engage any act that would infringe the mark. 2.4.4 Duration and renewal. It is possible for a proprietor of trademark to perpetuate the registration thereof. However, for administrative reasons, a time limit is generally provided for which a single act of registration is valid, but it is possible to renew registrations when this time limit expires. Section 25, TMA 1999 states that the registration of a trademark shall be for a period of 10 years, but may be renewed from time to time. Further, the registrar shall, on application made by the registered proprietor of a trademark in the prescribed manner and within the prescribed period and subject to payment of the prescribed fee, renew the registration of trademark for a period often years from the date of expiration of the original registration or of the last renewal of registration, as the case may be. One of the reasons for imposing such time limit is that the Trademarks Office can charge a fee for renewal, and it becomes a source of revenue for the office. Another reason for this approach is that registration of trademarks without a time limit would lead to an undesirable amount of trademark registrations that are no longer of any interest to their proprietors. Even if unused marks may be removed from the register, such a procedure would be costly and time-consuming for the interested party, and not always successful. Furthermore, The requirement of renewal coupled with a renewal fee is an opportunity for a trademark proprietor to reconsider whether it is still worth having his registration renewed, as the trademark may have been superseded in its graphic form or may even be no longer in use. In any case, renewals should be made simply on payment of the fee, without any new examination of the mark for absolute or relative grounds for refusal. 2.4.5 Rights arising from trademark registration. The registration of a trademark shall, if valid, give to the registered proprietor of the trademark the exclusive right to the use of the trademark in relation to the goods or services in respect of which the trademark is registered, and to obtain relief in respect of infringement of the trademark. Section 28, 1 TMA 1999. This provision gives two rights to the registered proprietor of a trademark: 1. The right to use the mark, and 2. The right to obtain relief by way of infringement times proceedings. It is important to make a distinction between these two rights, both derived from the right to use a trademark. The right to use the trademark: the registered owner has the exclusive right to use the trademark. It would indeed be contradictory not to grant such a positive right of use while imposing an obligation to use. The right of use is, however, subject to other laws and rights, as is the case with any other right provided by law. The right to use means the right of the proprietor of the mark to affix it on goods, containers, packaging, labels, etc., or to use it in any other way in relation to the goods or services for which it is registered. It also means the right to introduce the goods to the market under the trademark, the right to exclude others from using the mark. The right granted to the proprietor of a registered trademark is exclusive in nature, meaning thereby he has the right to exclude or restrain all others from using the mark without his permission. It follows from the mark's basic function of distinguishing the goods of its owner, those of others, that he must be able to object to the use of confusingly similar marks in order to prevent consumers and the public in general from being misled. He must be able to object to any use of his trademark by a third party for goods or services for which it is protected, 2. The affixing of mark on such goods, to its use in relation to the goods, and 2. The offering of the goods or services for sale under the mark, or the use of the mark in advertising, business papers, or any other kind of document. The exclusive rights of the trademark owner can be exercised by means of an infringement action. The trademark is infringed if, owing to the use of an identical or similar sign for identical or similar goods, there is a risk or a likelihood of the public being misled. This aspect of infringement of trademarks has been discussed elsewhere. 2.4.6 Exhaustion of trademark rights. Section 33b says that where the goods bearing a registered trademark are lawfully acquired by a person, the sale of the goods in the market or otherwise dealing in those goods by that person or by a person claiming under or through him is not infringement of a trade by reason only of the goods having been put on the market under the registered trademark by the proprietor or with his consent. This provision gives effect to what is known as the doctrine of exhaustion. That means when the trademark owner has launched a product on the market under his mark, he cannot object to further sales of the product in the course of trade. However, it is a principle that applies only to the right to launch the product bearing the trademark on the market for the first time. The proprietor's exclusive right to affix the trademark on the goods and their packaging, containers, labels, etc. continues to exist. Consequently, he can object to acts that infringe that right, such as the repacking of goods bearing his mark, the destruction of his mark on the goods, or the alteration and subsequent sale of his products under his mark. Altering the product and selling it under the same mark has the same effect as affixing the mark to goods, that is, it gives the consumer the impression that the genuine product has been marketed by the trademark owner under his mark. 2.5-point criteria for registration. A mark must fulfill certain criteria in order for it to be eligible for registration. In this regard, the Trademarks Act 1999 provides for absolute grounds and relative grounds for refusal of registration. Therefore, a mark must not come within these grounds for refusal. 2.5.1 Absolute grounds for refusal of registration. Section 9 of TMA 1999 deals with the absolute grounds for refusal of registration and aims to stop the registration of any mark which does not perform its essential function as a trademark, which is to distinguish the goods or services of one undertaking without any possibility of confusion from those of someone else. If the mark does the job, it doesn't matter if the mark is also slightly descriptive or laudatory. In JRYLLYNN Trademark 1999, FSR 491 at 497 Laddy J said, the distinction between a sign which is capable of distinguishing for the purposes of trademark law and one which is not can be turned into a question posed in colloquial language. Does the sign indicate who the product or service comes from, or does it only tell the customer what the product or service is? Distinctiveness. Section 9, 1A, TMA 1999 says that the trademarks which are devoid of any distinctive character, that is to say, not capable of distinguishing the goods or services of one person from those of another person, shall not be registered. The operative words in Section 9, 1A are distinctive character. Distinctive has a technical meaning in trademark law. It means to serve to guarantee that all goods bearing the mark come from the control of the same undertaking. A mark can be striking, fanciful, unusual, memorable or different, which can contribute to it being distinctive, but if it does not provide that guarantee of origin, it is not distinctive in law. The expression devoid simply means lacking, and the use of the word any before distinctive character could imply a low threshold, but in practice this is misleading. Descriptiveness. According to Section 9, 1B, TMA 1999, the trademarks which consist exclusively of marks or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, values, geographical origin or the time of production of the goods or rendering of the service or other characteristics of the goods or service shall not be registered. Section 9, 1B is applicable only when the mark consists exclusively of the descriptive material. If there is another element in the mark which has a distinctive character, the mark then cannot be considered under Section 9, 1B and instead should be considered under Section 9, 1A. The words which may serve in trade to designate suggests that a mark which is reasonably likely to be used by honest traders to designate characteristics of their goods or services ought to be refused without it being necessary to show that the sign is actually used or needed by the trade in question. Further, the expression may serve to designate allows for a degree of foreseeability that the mark may be perceived by the relevant class of persons as a new form of descriptive expression. It doesn't stand to logic that why the exclusion from registration contained in Section 9, 1B should make no allowance for the advent of new forms of descriptive expressions. The test is to determine whether the trademark submitted for registration does the job of distinguishing as to origin or merely describes the purpose of or a characteristic of goods or services. The sign need not be totally non-descriptive. A useful question to ask is how would a reasonable person view the mark? as an origin-neutral reference to the goods or services on which it is to be applied, or as an identifier of origin? If the former, an objection should be taken. If the latter, the sign performs the essential function of distinguishing as to origin generic marks, according to Section 9(1)(c). The trademarks which consist exclusively of marks or indications which have become customary in the current language or in the bona fide and established practices of the trade shall not be registered. This provision applies to only those marks which consist exclusively of the prohibited matter. If there is any other element in the mark with a distinctive quality, the mark should not be refused registration on this ground. Such composite marks could, however, conflict with the requirements under Section 9(1)(a). For example, any mark which is the commonly used .and accepted name of any single chemical element or compound will fall within the provisions of this section if registration is sought for goods being a chemical substance or preparation. Similarly, a spanner device for car servicing, a chef's hat for restaurant services, a bunch of grapes for wine, etc. are examples of devices which are customary in the established practices of the trade concerned. Only those marks which have become customary are prohibited from registration. The words have become and current in the section wording combines to exclude speculation on whether use of the mark may become customary in the future. The mark must have an already established meaning. Further, some signs would only be in customary use in a particular field. Cyber would be totally unregisterable for computer software but should raise no objections for detergent marks which become generic after losing distinctive character are known as genericized trademarks. A trademark is said to be genericized when it began as distinctive but has changed in meaning to become generic. A trademark typically becomes genericized when the products or services with which it is associated have acquired substantial market dominance or mind share such that the primary meaning of the genericized trademark becomes the product or service itself rather than an indication of source for the product or service to such an extent that the public thinks the trademark is the generic name of the product or service. Genericization or loss of secondary meaning may be either among the general population or among just a subpopulation. For example, people who work in a particular industry. Examples of genericized trademarks are aspirin, which was originally a trademark of Bayer AG, escalator, which was originally a trademark of Otis Elevator Company, and kerosene, which was originally a trademark of Abraham Gessner. Acquired distinctiveness through use. Section 9(1)(a) emphasizes that a mark should be inherently distinctive before it is capable of being registered. But this is only one of the ways in which a mark may be distinctive. The other way is making a mark distinctive by use. The proviso attached to Section 9(1) TMA 1999 states that a trademark shall not be refused registration if before the date of application for registration it has acquired a distinctive character as a result of the use made of it. The distinctiveness acquired by the use of the mark must exist before the date of the application to register. No consideration will be given to any likelihood that the mark will or might become distinctive in future due to any advertising or promotion by the mark's owners. Common surnames and personal names, descriptive words, misspellings of descriptive words, geographical place names, etc. are the kinds of marks which are likely to have been refused registration under Section 9(1)(a), (b), or (c), which can be considered for registration with evidence of acquired distinctiveness. For how long should such a mark have been used so that it could be credited with the status of acquired distinctive character? In this regard, there is no fixed period of use. Extensive use over a shorter period may well be sufficient. Use should be continuous, though impressive sales after a gap may well establish that the distinctiveness acquired before the gap has not been lost. Market share held by the mark, intensiveness, geographical reach and long-standing use of the mark, the amount invested by the owner in promoting the mark, the number of people who, because of the mark, identify the goods as originating from the particular owner, and statements from chambers of commerce and industry or other trade and professional associations, etc. could be taken into account in assessing the acquired distinctive character of a mark. The purpose of the evidence is to demonstrate that, despite the objectionable nature of the mark, it had in fact, prior to the application for registration, become identified in the minds of the public with a particular trader's goods or services. That is what is meant by distinctive character. Proof of extensive or exclusive use or extensive promotion alone may not satisfy the requirement of establishing distinctive character on a highly descriptive or commonplace mark. Additional evidence of public or trade recognition is necessarily required. Whether the mark has acquired a distinctive character also depends on degree. The onus rests on the applicant to prove the case. Applicants may uplift and refile or adopt evidence filed for the earlier mark to assist in proving acquired distinctiveness. Times, public policy objections in registering marks. According to Section 9, 2 TMA, 1999, a mark shall not be registered as a trademark if it is of such nature as to deceive the public or cause confusion. That means even if a mark has qualified to be distinctive under Section 9(1), still if its nature is such which might deceive the public upon its usage, then it will not be registered. This provision places public interest higher than any private interest of the applicant in the mark. The types of deception that could lead to an objection under this subsection are not specified. Clearly, they would include marks which give rise to an expectation which will not be fulfilled. For example, if the composition of goods does not go with the mark, then it should not be registered under this provision. When the mark pure is appended to juice when it contains synthetic materials, then the case could squarely fall under this head. If a mark contains or comprises of any matter likely to hurt the religious susceptibilities of any class or section of the citizens of India, or comprises or contains scandalous or obscene matter, or its use is prohibited under the Emblems and Names Prevention of Improper Use Act 1950, then it cannot be registered. 2.5.2 Relative grounds for refusal of registration. Where there exists a likelihood of confusion with an earlier trademark, there can be relative grounds for refusal of registration. As per Section 11(1) TMA 1999, this occurs when an identical trademark is to be used on goods or services which are similar to the earlier registered mark, or where a similar trademark is to be used on goods or services which are identical or similar to an earlier registered trademark. Objections to registration under Section 11 can only be taken if conflicting mark is an earlier trademark. An earlier trademark means a registered trademark or a trademark which, on the date of the application for registration of the trademark in question, or where appropriate, of the priority claimed in respect of the application, was entitled to protection as a well-known trademark. Even if there is only a slight difference in the visual appearance, the marks are not identical. In IGNOU Communications Ltd.'s Trademark Appellant 2002, RPC 283, the court held that digit was not identical to digit H tilde cause of absence of the letter S. where the mark seeking registration is identical to an earlier mark but the goods or services are merely similar to those for which the earlier mark is protected, registration will only be refused if the use of the later mark in relation to its specified goods is likely to cause confusion on the part of the public. The same test applies where the later mark is similar to the earlier mark and the goods or services are either identical or similar to those for which the earlier trademark is protected. Likelihood of confusion refers to confusion as to the origin of goods or services in question. Carelessness or indifference on the part of consuming public should not to be regarded as synonymous with confusion or likelihood of it. The assessment of likelihood of confusion on the part of the public includes the likelihood of association with an earlier mark 2.5.3 honest concurrent user, according to Section 12, TMA, 1999, in the case of honest concurrent use or of other special circumstances which in the opinion of the registrar make it proper so to do, he may permit the registration by more than one proprietor of the trademarks which are identical or similar, whether any such trademark is already registered or not, in respect of the same or similar goods or services, subject to such conditions and limitations, if any, as the registrar may think fit to impose. 2.6 Procedure for registration of trademarks. At the national level, an office is established for the purposes of registration of trademarks. In India, the Office of Registrar of Trademarks has been established for the maintenance of trademark registry. The Controller General of Patents and Designs is also the Registrar of Trademarks. The Registrar of Trademarks contains the record of all registered trademarks with names and addresses of proprietors and registered users of trademarks. The procedure of registration is as follows. 2.6.1 Application for registration. Any person claiming to be the proprietor of the trademark is entitled to obtain registration by filling a request in the prescribed manner and by paying the requisite fee. The application may be made in the name of an individual, the partners of a firm, a company, a government department, a trust or any other entity having legal personality. Two or more persons may also make a joint application. The application has to be filed in the office of the Trademarks Registry within whose territorial limits the principal place of business in India of the applicant or, in the case of joint applicants, the principal place of business in India of the applicant whose name is first mentioned in the application as having a place of business in India is situate. Where the applicant or any of the joint applicants does not carry on business in India, the application shall be filed in the office of the Trademarks Registry within whose territorial limits the place mentioned in the address for service in India as disclosed in the application is situate. Section 18, TMA, 1999. The application may be accepted absolutely or subject to some amendments, modifications, conditions or limitations, or it may be rejected by the registrar. In the case of a refusal or conditional acceptance of an application, the registrar shall record in writing the grounds for such refusal or conditional acceptance and the materials used by him in arriving at his decision. It is possible that after acceptance of application but before registration some errors are detected. In that case, the registrar has the power to withdraw his acceptance. The registrar may also, on such terms as he thinks just, at any time, whether before or after acceptance of an application for registration, permit the correction of any error in the application or permit an amendment of the application. The application is numbered as per seriatim and date. The application number and date of filing ultimately become the registration number and date of registration. if the application is able to overcome the objections as may be raised by the registrar under Section 9 and Section 11 of the Trademarks Act, 1999, and the opposition proceedings, if any, initiated by third party. 2.6.2 Advertisement and Opposition, FE, after an application has been filed, it is then advertised in the Trademark Journal by the registrar together with the conditions or limitations, if any, subject to which it has been accepted. This advertisement provides the public to oppose the registration of trademark concerned. Any person may, within 3 months from the date of the advertisement of an application for registration or within such further period, not exceeding 1 month in the aggregate, as the registrar, on application made to him allows, give notice, in writing in the prescribed manner to the registrar, of opposition to the registration. The registrar thereafter serves a copy of the notice on the applicant for registration, and within 2 months from the receipt by the applicant of such copy of the notice of opposition, the applicant shall send to the registrar a counter-statement of the grounds on which he relies for his application, and if does not do so, he shall be deemed to have abandoned his application. If the applicant sends such counter-statement, the registrar shall serve a copy thereof on the person giving notice of opposition. The registrar, after hearing the parties, if so required, and considering the evidence, decides whether and subject to what conditions or limitations, if any, the registration is to be permitted, and may take into account a ground of objection, whether relied upon by the opponent or not. 2.6.3 Registration and Certification. When an application for registration of trademark has been accepted and either the application has not been opposed and the time for notice of opposition has expired, or the application has been opposed and the opposition has been decided in favor of the applicant, the registrar shall register the said trademark. On the registration of a trademark, the registrar shall issue to the applicant a certificate of the registration thereof, sealed with the seal of the Trademarks Registry, R, where registration of a trademark is not completed within 12 months from the date of the application by reason of default on the part of the applicant, the registrar may, after giving notice to the applicant in the prescribed manner, treat the application as abandoned unless it is completed within the time specified in that behalf in the notice. 2.6.4 Date of registration. The proprietor's exclusive right exists from the date of registration. The trademark, when registered, shall be registered as of the date of the making of the said application, and that date shall be deemed to be the date of registration. That means the priority of the right dates back to the date of filing for registration. While it is true that the application is not normally a sufficient basis for bringing an infringement action against a later right, it must be a valid basis for an opposition procedure. And even more importantly, the date of the application for registration will be decisive in a later court case. The time that passes before an application leads to registration varies a great deal and in certain cases can be very long. A later application can for various reasons lead to registration sooner, for instance where the earlier application was refused by the examiner and finally granted on appeal. Clearly, the owner of the earlier application must have the prior right in relation to the owner of a later application. Furthermore, the applicant can claim the priority of his national registration under Article 4 of the Paris Convention if the application in the foreign country is made within 6 months of the filing date of the first application. 2.6.5 Publication and access to the register. It is important for owners of prior rights and the public that all relevant data contained in the register concerning applications, registrations, renewals and changes of name, address and ownership should be published in an official gazette. This enables owners of prior rights to take the necessary steps, including opposition, if provided for, or an action for cancellation. 2.7 Removal of the trademark from the register. The rights to a trademark can be lost through abandonment, improper licensing, or assignment, or genericity. A trademark is abandoned when its use is discontinued with an intent not to resume its use. Such intent can be inferred from the circumstances. Moreover, non-use for 3 consecutive years is prima facie evidence of abandonment. The basic idea is that trademark law only protects marks that are being used, and parties are not entitled to warehouse potentially useful marks. Trademark rights can also be lost through improper licensing or assignment where the use of a trademark is licensed, for example, to a franchisee without adequate quality control or supervision by the trademark owner. That trademark will be cancelled. Similarly, where the rights to a trademark are assigned to another party in gross without the corresponding sale of any assets, the trademark will be cancelled. The rationale for these rules is that, under these situations, the trademark no longer serves its purpose of identifying the goods of a particular provider. Trademark registration is not an end in itself. Even though trademark laws generally do not require use as a condition for the application for trademark registration, or even the actual registration, the ultimate reason for trademark protection is the function of distinguishing the goods on which the trademark is used from others. It makes no economic sense, therefore, to protect trademarks by registration without imposing the obligation to use them. This is especially true in the light of the fact that trademark registration does not give an absolute monopoly to the registrant over the mark. Unused trademarks are an artificial barrier to the registration of new marks. There is an absolute need to provide for a use obligation in trademark law. The cancellation of a trademark registration is a serious matter for its owner, as it leads to a loss of his rights under the registration. As a matter of fact, there are a number of grounds on which a trademark can be removed from the register. 2.7.1 Removal for failure to renew. It has been shown that, for administrative reasons, a trademark is registered for a certain period of time. If the owner fails to renew his trademark registration, and more specifically fails to pay the renewal fee, this leads to the removal of the trademark from the register. Registries generally allow a period of grace for payment of the renewal fee, usually with a surcharge. If the law permits renewal of the trademark registration for just some of the registered goods to be encouraged as a means of removing deadwood from the register, this leads to a partial cancellation of the trademark registration for all the goods in respect of which it is not renewed. 2.7.2 Removal at the request of the registered owner. The registered owner can himself, at any time, renounce his registration for either all or some of the goods for which the mark is registered. At the request of the registered owner, therefore, the authorities will in principle remove the mark from the register either wholly or in part. 2.7.3 Removal for failure to use. If the owner of a trademark fails to use his mark within the grace period provided for in the law, any interested party can, in principle, ask for its cancellation. If the owner cannot justify the non-use, removal of the registration is ordered by the court. If the owner can prove use or justify the non-use, but only for some of the registered goods, the court orders partial cancellation. Partial cancellation extends either to all registered goods for which use cannot be proved, or at least to all those not similar to the goods that the registered owner has used. This does not mean that the registered owner's rights would be strictly limited to the goods used. or even to a single product on which his trademark has been used. Even if his registration is cancelled for all but the one product for which he can prove use, he can still defend his exclusive right to his registered trademark against the registration. 2.7.4 Cancellation on account of nullity. If a trademark consists of a sign that should not have been registered, it can be declared null and void by the court at the request of any interested party. Sometimes trademark laws also provide an ex officio procedure for that purpose. As a consequence of the declaration, the trademark is removed from the register if the grounds for invalidity exist only with respect to some of the registered goods. The registration is removed for those goods only. Normally, removal from the register is ordered only if the grounds for invalidity already existed when the trademark was registered. Moreover, even if trademark should not have been registered owing to lack of distinctiveness, its cancellation is not permitted if in the meantime it has become distinctive by use. Such acquired distinctiveness cannot, however, prevent the removal from the register of trademarks that consist of generic or deceptive terms. And yet there can be exceptional cases in which the deceptive meaning that would have prevented trademark registration at the outset has been lost in the meantime. 2.7.5 Removal of a mark that has lost its distinctiveness. If the registered owner has provoked or tolerated the transformation of a mark into a generic name for one or more of the goods or services in respect of which the mark is registered, the mark becomes liable for removal from the register. A mark may become liable for removal from the register if the registered owner has provoked or tolerated its transformation into a generic name for one or more of the goods or services in respect of which the mark is registered, so that, in trade circles and in the eyes of the appropriate consumers and of the public in general, its significance as a mark has been lost. Basically, two things can cause genericness, namely, improper use by the owner, provoking transformation of the mark into a generic term, and improper use by third parties that is tolerated by the owner. Trademarks such as Frigidaire, cellophane and linoleum became generic terms because they were the only product in their category and no additional name was given to the category by its proprietors. 2.8 Summary. Times trademark rights could be acquired on the basis of either use or registration. Both systems have developed historically. However, the use system predates the registration system. Times in India, registered trademarks are governed by the Trademarks Act 1999 and common law, whereas unregistered trademarks are governed by the law of passing of which is a part of common law. Registration of trademarks is not compulsory in India. Nevertheless, trademark registration brings forth certain advantages which are not available to a trade over a trademark obtained under common law. A time limit is generally provided for which a single act of registration is valid, but it is possible to renew registrations when this time limit expires. Times the registration of a trademark shall, if valid, give to the registered proprietor of the trademark the exclusive right to the use of the trademark in relation to the goods or services in respect of which the trademark is registered, and to obtain relief in respect of infringement of the trademark. Times the right to use means the right of the proprietor of the mark to affix it on goods, containers, packaging, labels, etc., or to use it in any other way in relation to the goods or services for which it is registered. Trademarks which are devoid of an 1.0 distinctive character, that is to say, not capable of distinguishing the goods or services of one person from those of another person, are not registrable. Times trademarks which consist exclusively of marks or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, values, geographical origin or the time of production of the goods or rendering of the service or other characteristics of the goods or service cannot be registered. A trademark shall not be refused registration if before the date of application for registration it has acquired a distinctive character as a result of the use made of it. Times FE times where an identical trademark is to be used on goods or services which are similar to the earlier registered mark or where a similar trademark is to be used on goods or services which are identical or similar to an earlier registered trademark. The latter trademark shall not be registered. Times in the case of honest concurrent use or of other special circumstances, the registrar may permit the registration by more than one proprietor of the trademarks which are identical or similar in respect of the same or similar goods or services. Times the rights to a trademark can be lost through abandonment, improper licensing or assignment, or genericity. Thank you for watching. We will see you in the next video with next chapter.